Bonjour tout le monde. Aujourd'hui, c'est un grand plaisir et un grand honneur d'accueillir dans notre série de conférences sur les regards institutionnels sur la propriété intellectuelle, un des acteurs majeurs, si ce n'est l'acteur majeur quand on parle de développement international de la propriété intellectuelle, puisque nous avons le plaisir aujourd'hui d'accueillir Francis Gurry, qui est le directeur général de l'Organisation mondiale de la propriété intellectuelle, qui a été aussi, on a eu la chance de l'avoir pendant 3 années, aussi président du conseil d'administration du CEPI. I will switch to English now because even though Francis Gurry speaks perfect French and gave me the choice whether I would like it in French or English, we decided for English because also the conference is filmed and will be broadcasted afterwards on the internet, so available in all corners of the world. And unfortunately, it's not French, the dominant language in the world, so with English we might have a broader audience. So Mr. Gurry was here in the context of a celebration last night. He has been awarded the Academic Palms, which is a high distinction for his action at the head of the Administrative Council of CEPI for 3 years. But what you need also to know is that Mr. Gurry is almost a scholar, I would say, and he started his career at the university. You might be familiar with one of his leading books on breach of confidence, published in 1984, and which had a second edition at Oxford University Press in 2012. And I can also recommend you his very interesting article on the international developments in intellectual property law, which was published in the 50th anniversary book on intellectual property law in a time of change. So you will recognize immediately that Mr. Gurry is not only the head of the major agency in the world when it comes to IP, but is also a thinker and a visionary. With this introduction, what is left to me is to thank you very much, Francis, for coming to Strasbourg to share your insights on what are the challenges for intellectual property on the international level. Thank you very much for your support over the years to CEPI. And without further ado, you have the floor for 40 minutes, and then we'll take question and answers from the floor. The questions can be also, if you don't feel confident enough with English, can probably also be addressed in French. So Francis, thank you.
Merci Christophe. Je dois appuyer ou non? Non, c'est bon. Ok, merci Christophe, mesdames, messieurs. Bonjour, je vais dire juste quelques mots en français pour commencer. Pour vous saluer, pour dire que c'est un très très grand plaisir d'être de retour à Strasbourg et dans cette université magnifique et ce centre CEPI magnifique. Je dirais tout au commencement que je vais parler d'une manière assez large de la question, ou plutôt du contexte de la propriété intellectuelle, parce que je pense que c'est ça qui est très important. Et à la fin, je vais essayer de le ramener plus au concret, plus à la réalité et non par la pensée. Et je dirais aussi au commencement que je trouve que c'est de plus en plus difficile de parler de la propriété intellectuelle dans un espace qui est moins de 20 heures, en fait. Je ne vais pas faire ça ce matin, mais c'est devenu une matière tellement vaste qu'il était extrêmement difficile, je trouve, de parler de l'ensemble de la propriété intellectuelle et de voir ce qui se passe. Maintenant, je vais passer en anglais, si vous me le permettez, et vous n'avez pas beaucoup de choix là. I would start with a very broad proposition, if I may, that technology is the great differentiator in history and in contemporary societies. Now, that's a proposition that requires quite a lot of support, and I'm not going to do that this morning other than on a very anecdotal level. But, and there are a few random anecdotes to support that view. I think the view is recognized in the way in which we actually break up the ages of evolution, the Stone Age, the Iron Age, the Bronze Age, the Industrial Age, the Information Age. It's basically on the basis of technology. And technology, let us remember, is not just the source of economic power, but it's also the source of military power. And that has been the case since, well, it's always been the case, and it's certainly been the case, for example, since Genghis Khan and the invention of the stirrup, l'étrier, which permitted his horsemen to fire arrows on the run and gave them an enormous military advantage. And that is the case, I would say, right across history, up, until and including the crypto-analytic capacity which enabled the cracking of the Enigma code in the Second World War. And then I think if you look at the corporations in the world today, the 5 biggest corporations by market capitalization in the world are all technology companies. And they are Apple, Alphabet, which is the parent, of course, of Google, Microsoft, Amazon, and Facebook. They're all technology companies, and that's a very different situation from the one which we had 30 or 40 years ago. So if that has always been the case, and I would suggest that it is, what has changed? And here I'd say that 3 things in particular have changed in this context. And the first of those is scale or dimension in the knowledge economy. The place of knowledge in the production and distribution of goods and services is predominant now. And there are many, many measures of that shift away from physical capital being the source of wealth generation towards intellectual capital being the source of wealth generation. There are many indicators that you can use. The value of intangibles. I don't know whether you've seen, for example, the valuations that are given for trademarks or brands these days. But on one survey, and these are always subject to close analysis, but on one survey, they valued last year, and it was published by the Financial Times, the Google brand at $230 billion. And second place was Apple at $228 billion, and then you went down quite a bit to Microsoft at $121 billion. Notable, they're all technology companies again, but if you look at the market capitalization of those companies, the Google's market capitalization, of course it changes every day, is around about $515 billion. So the brand valuation actually is 44% of its market capitalization. And the same is true of Apple. It's about 41% of its market capitalization. So knowledge has a very predominant position, And you can look equally at research and development expenditures, the generation of new knowledge around the world. And the estimate this year is that it'll be about $1.95 trillion, $2 trillion if you like, invested in the generation of new knowledge in research and development. Now, if you look at Italy, which is still the 8th largest economy in the world, its GDP is about $1.9 trillion. In other words, more is invested around the world in the generation of new knowledge now than the total production of the 8th largest economy in the world. And you can go on and on and on. There are many, many other indicators of the scale of the place of knowledge in production now, which is something completely different, I think, from previously. It's a previous situation. It's always been important, but now it is predominant. I'd say the second thing that's changed is speed. The speed with which technological change occurs. If you like, history is accelerating. So from the point of view of anthropology, if you look, it's very interesting to look at the timelines. It took human beings about 5 million years after their appearance as something that could be described as humanoids, 5 million years to reach bipedalism, to start to be able to walk on 2 feet, liberating their hands for tool making, actually. And then it took another 1.8 million years for the mastery of fire. And then it took 700,000 years to reach the agrarian or agricultural revolution. And then 12,000 years to reach the Industrial Revolution, and then 150 or 60 years to reach the Information Revolution. So you see this compression of timelines constantly occurring to such a point that the British intellectual who died about 3 years ago, Tony Judd, said, "We are losing our memory because change occurs so quickly now that we do not have the time to absorb what has happened and to assimilate it." We had 150 years to absorb the Industrial Revolution and to understand or try to understand what that meant. These days, of course, it changes at a much, much quicker rhythm. So speed, scale, speed, and then I think thirdly, as a consequence really of those first two things, radical and continuous change or disruption. So this has been described by many people in different ways. For example, the fourth industrial revolution, various other descriptions for the convergence that we see of many technologies, information technology and biology, for example, bioinformatics, smart manufacturing or advanced manufacturing using robots and sensors, and so on and so on and so on. So we have a situation really of rather constant disruption in the economy as a consequence of technology. So now, with those general observations about the importance of the place of technology in history and in contemporary society and what has changed maybe in relation to technology on a very large scale, I wanted to look at some of the consequences of that. And I think the first consequence, which is something that you're all familiar with, is that innovation, of course, or the creation of new knowledge and its introduction into the economy in terms of new goods and services, has become the central plank of the economic strategy of most countries around the world. Now, if you take the United States of America, the largest economy, this, I think, has probably always been the case, but it's certainly been the case since the end of the Second World War, when in about 1944, President Truman commissioned someone named Vannevar Bush to look at the task of how to convert a military economy into a peacetime economy, and he wrote a report called Science, the Endless Frontier. It's a wonderful report, and it's only about 40 or 50 pages. Science, the Endless Frontier, as the central plank which set in place the National Science Foundation and a number of other institutions in the United States of America. But it's also the case for the second largest economy in the world, which is China. So China is officially now on a journey from made in China to created in China. So it is a transformation from being the factory of the world to being the laboratory of the world, if you like. And this is, of course, extremely important for it. If you happen to have an iPhone and you look at the back of it, you'll see in very, very small print, such small print that I can't read it, designed in California and assembled in China. And it's a good example because 10% only of the value of this goes to the assemblage in China. 90% is in the intellectual property in California. China, this is the case. It's the case for Japan, of course, and it's the case for Germany, the fourth largest economy, and you can go through and you find that innovation is a central plank of the economic strategy of most economies now. And I think it's not just the advanced economies, it's also the middle-income economies where they are looking to create more sustainable economies which are less volatile and less vulnerable to the movement in commodities prices. The way of doing that, of course, is through value addition, in other words, through innovation. It is, as I said, right across the world, nobody wants to compete on the cost of labour. Nobody wants to have the lowest labour cost because that obviously affects your standard of living. So innovation is now a central plank, so much so that one economist has called it, has said it's a fetish, really. Everyone talks about innovation all the time. I think then a second consequence that we see as a result of that changed position of innovation is that intellectual property is exploding. It is exploding. Now, why is that the case? Well, because essentially what intellectual property does, as you know, is to capture the competitive advantage that is conferred by innovation. So all of this investment in innovation, the central part of the economic strategy, you have intellectual property as the mechanism which preserves or protects the competitive advantage that results from this enormous investment in innovation all around the world. To use terminology invented by Warren Buffett, actually, intellectual property enables an enterprise to construct an economic moat, a fosse, around the competitive advantage conferred by innovation. And so we see that increasingly enterprises are using what I would say is cumulative protection, or they're using all of the elements of intellectual property to preserve that competitive advantage conferred by innovation. You see that in films. So once the way to monetize, as we say crudely in English, films was, of course, through copyright, but these days it's as much with trademarks and merchandising as with copyright. You see it in pharmaceuticals, where the reliance is not just on patents, but also on trade secrets, data exclusivity, and branding to lengthen the competitive advantage. And you see it in smartphones, where it is patents, its designs, and its branding as well. So a cumulative approach to protecting, to using all available means of intellectual property to construct the economic moat, or fosse, around the competitive advantage conferred by innovation. And thus we see an explosion in demand for intellectual property. So we published just a couple of weeks ago the worldwide survey in 2015 for what was happening in the field of intellectual property. And it's about 2.9 million patent applications worldwide. It's about 6 million trademark applications, counting them on the basis of one class. And it's about 870,000 design applications. And this in a context of a world economy which is generally considered to be underperforming. This sector is not underperforming. It's a growth rate in the patent area of 8%, a growth rate in the trademark area worldwide of 15%. A much lower one in designs, it's about 2.3%, but that's explicable on the basis of China and its particular activities. So a marked contrast, it's another confirmation, if you like, of the scale of the knowledge economy, or the scale of the importance of knowledge in the contemporary economy, is that this sector of intellectual property has consistently outperformed the world economy for the last 10 years. It is not suffering in the same way as the rest of the economy. I think in that, what we also see then is that intellectual property has become the basis of competition. When I started in my present position, I had the opportunity to meet the then Prime Minister of China, Mr. Wen Jiabao, and the very first words that he said to me were, intellectual property will be the basis of competition in the future. And since that was in about 2008, and since that time I've been thinking about that, and it certainly seems to me to have been a very perceptive observation and absolutely right. And I think, therefore, I think that you see that competition around with the use of intellectual property and in relation to innovation at all levels. So it's not just between enterprises, it is, of course, between enterprises where they are using intellectual property in the smartphone industry, for example, as the battleground for preserving the innovative competitive advantage. But I think you see it in state policies, in all of the policies that are adopted by states around the world. So we have done some surveys at WIPO. My colleagues in the economics office on inventors, for example, because the patent system gives you great data about inventors. And 57% of all inventors in the filing patent applications who are resident outside their country of origin are in the United States of America. There is competition for human resources, and that is fierce competition. So Silicon Valley is like a big magnet attracting some of the best resources in human resources in the world. And many other countries are adopting policies which will enable them to also preserve human resources, their human resources, or attract their human resources. It happens in regulatory systems. For example, the experiment on the part of the British to have a patent black box where they offered a lower rate of tax on any profits derived from intellectual property that you would bring into the jurisdiction, provided you worked it. So that competition, I think, really is happening at absolutely all levels. It's happening between countries to position themselves in the innovation race, and it's happening between enterprises to position themselves in the innovation race. And I think the major change that we have seen in this regard also is the geography of that competition. So it's quite remarkable. Of course, China is the game changer in all of this, and you're probably sick of hearing the statistics on what has happened in China, but it is something quite exceptional. If you go back 20 years ago in our patent cooperation treaty, in terms of international patent applications, of course, you had from Asia about 7.6% of all applications, all international patent applications were coming out of Asia. Last year it was 43%. So China passed Germany in terms of the number of international patent applications it was filing. We're talking about numbers, of course, and not quality, but the truth is we don't have a reliable metric for quality. If we had a reliable metric for quality of an invention in a patent application, you wouldn't need a venture capital industry. So we don't have that reliable metric. But an extraordinary change. And I think it's worth looking at what the strategy, for example, of China is. It's not only in terms of building the capacity to be able to use the intellectual property system in a way to protect the competitive advantage, but you, I think, see that it's a major strategic focus in absolutely everything. So take Xiaomi, which is the Chinese smartphone that is most popular on the market, Xiaomi. So of course, China has a huge domestic market, and it was able to have extraordinary sales of this smartphone in its domestic market. Then it started to want to export this, and then it ran into what problem? Intellectual property. And accusations by two companies, Blue Spike and Ericsson, that actually it had used intellectual property in its smartphone that belonged to those companies. What was the response? Well, it bought 1,500 patents from Microsoft. It bought 1,500 patents, which enabled it then to have a chip in the bargaining of cross-licensing in relation to the competition occurring on the basis of intellectual property. There are many other examples if you follow this. So Midea, which is another Chinese company, purchased this year KUKA, which is the largest maker of industrial robots in China, for $4 billion. Okay? It caused consternation in Berlin and in Brussels, but the sale went ahead. And you can multiply the examples. So this strategy of use of intellectual property as a competitive tool and acquisition of intellectual property in order to place you is something that is playing out all around the world. And then I would come to perhaps my last change factor. And it's not so much a change factor, it's always been there, but again, a difference of scale, and that is the enormous asymmetries or differences in technological capacity that exist across the world. Enormous, I mean, just extraordinary. So I gave you some figures for investment in research and development a bit earlier, but the reality is that in a multilateral organization with 189 member states, you have countries that have pre-industrial economies, you know, whose major task is to go from subsistence agriculture to commercial agriculture. And you also have countries that are post-industrial economies. So you have the whole range, from pre-industrial to post-industrial, expressed in the membership. And the differences are absolutely fantastic. So if you look at research and development again, the United States this year will spend about $514 billion on research and development, the generation of new knowledge. That is more than the GDP of 167 countries in the world. China will spend $400 billion. That's about $396 billion. It's the second largest investor in R&D. That's more than the GDP of 163 countries in the world. So, of course, I'm comparing apples and oranges there, but if you consider that one country is investing in the generation of new knowledge more than 167 countries each have to satisfy all their needs for infrastructure, education, health system, roads, and so on, this is extraordinary, the differences that exist in the world. And you can take it on an individual level. The largest individual investor in research and development this year will be Volkswagen, which will invest around about $15 billion in research and development. That's greater one company than the GDP of 74 countries. So technology is a divider, actually. It is a great divider and, in a diverse membership. Now, coming to down to earth a little bit, or trying to, on intellectual property. There are many, many things that one can say. As I said at the outset, it's very increasingly difficult to talk about intellectual property in a short space of time. But coming down to earth a bit, I think one of the biggest consequences of all this is for policy making. I think the accelerated pace of change, so the speed factor, is placing enormous stress on our traditional institutional machinery for developing and making policy in the area of intellectual property. In fact, I would say that if you look around the world at the moment, change is being driven by technology and by the market response to technology, and not by legislation, not by legislators. And I think the biggest example of that is the digital revolution. So as you're all very much aware, we have seen unfold in the course of the last 20 years, a true revolution in the way in which creative works are created, curated, produced, distributed, and consumed. The whole thing has changed. The whole architecture for creative works has changed enormously. And that has not been a consequence of policies adopted by governments. It's been a consequence of technology and the market response to technology. So we've all been very worried for many years about the extent to which the creative industries will still remain viable in this environment in which is characterized by, once it's out there on the internet, it's out there for everyone, and ease of reproduction. And I would suggest that the real impact on that problem has been the development of new business models, streaming and subscription models, not legislation putting teenagers in jail or whatever. It has been actually the development of new business models in the market. So to some extent, what we're doing, what we're seeing now as a consequence of the importance of technology, the speed with which it's developing, is that our traditional policy-making processes are watching what is happening in the market with the development of new technologies and assessing whether to intervene or whether not to intervene. And I think the great example of that is the discussions that are taking place in Europe on the development of a single digital market at the moment. Should they intervene? Should they not intervene? If they intervene, is it going to upset this market development of changing business models, and how will it upset that? And I read coming here the article, the opinion done by Christophe and two colleagues here at CEPI on the proposed directive of the European Commission introducing a publisher's right, proposing to introduce a publisher's right. Very, if I may say, extremely good and well thought out and carefully analysed opinion. But there is a paralysis in policy making, because the process of making these changes is so slow compared to the way in which the market adapts in response to new technologies. I think this is something we all need to think about in a major way. It's a very radical change. And one of the other consequences, I think, that we have of that is that the courts are being called upon to decide policy questions because legislatures are not necessarily responding sufficiently quickly. The courts are the ones where the policy decisions are being taken actually. So there are many examples of that, but let me just give you one example. In the United States of America, the United States Supreme Court has taken more cases in the field of intellectual property in the course of the last 5 years than any other field, any other sector of economic activity. So this pressure on the courts to decide questions which are uncertain because the law hasn't changed, but the technology has and the business models have changed, is another feature, I think. Not only are legislatures in difficulty, but also I think you see the same with the court system. It's been called upon to make policy decisions in many instances, whether it's gene patenting or whatever the field. Now, let me come to multilateralism as the last area and say that in all of that, what I think you obviously have is a multi-speed and multi-layered world. So it's a world which is moving at different paces as a result of the great asymmetries that exist, the great differences that exist. And it's got various layers. I think if you went back some, even only 20 years ago, but certainly 30 years ago, you basically had national policy making and international. But now you have complexity. You have national, bilateral, plurilateral, regional, and multilateral. So multi-layers in the policy response. Because states, remembering what I said about the strategy, innovation being a central plank of strategy, of economic strategy, states will use any available forum to advance their interests. So if the multilateral is not working, they'll try to do it bilaterally or plurilaterally. They'll try to do it through a bilateral free trade agreement or through the Trans-Pacific Partnership or TTIP or the Belt and Road Initiative or whatever it might be. And that's, I'm merely making an observation there, I'm not making a criticism. That's the world in which we live. It's multi-speed, it's multi-layered, and it's complex. And there are a lot of questions that arise out of that. A lot of questions. And I sometimes think, you know, why is it so difficult to advance in the field of intellectual property? And I would say that the two greatest difficulties coming out of what I said earlier are that intellectual property is about competitive interests. So if you go to the World Health Organization, everyone is interested in finding a way of dealing with Ebola. There's no difference of interests. We're all interested. Some might be more affected, more immediately affected, but we're all vulnerable and exposed, and there's a community of interest in relation to the subject matter which gives the possibility of finding solutions and finding agreement. But that's not the case in intellectual property. We, of course, like to think, those of us who work in the field are new, that, well, we have a common interest in protecting creators, in ensuring a creative environment, in protecting innovators. But actually what's playing out is competitive interests. So let's take, as one example, the revision of the Lisbon Agreement at WIPO. So I'm not sure how familiar you are with that, but the Lisbon Agreement is an agreement which was concluded in 1958, a long time ago, to have an international register and international protection for appellations d'origine, appellations of origin. So one form, species of geographical indication, if you like. Because it was appellation d'origine, which is not widely used as a system. Of course, it's very strong in France, very strong in Italy, but many countries use geographical indications rather as the species of property. It only attracted, over the course of the 50 or 60 years of its existence, about 28 member states, contracting parties. And as you know, at the same time, there had been for 20 years a trade dispute played out in bilateral free trade agreements and played out at the World Trade Organization in the TRIPS Council, in which basically, and I summarize, please excuse the simplification, but basically you had the old world, if I may say, so Europe, trying to enhance the level of protection for geographical indications, raise the level of protection for non-wines and spirits geographical indications, other agricultural produce, cheeses, Venetian glass, and so on, raising that. And on the other hand, resistance from, if you like, the New World, United States, Canada, Australia, Argentina, Chile, which for the most part are countries of immigration, and for the most part, you know, people came to those countries and said, well, you know, what I would like to do is make a beer like Budweiser, like the beer we had in the Czech village of Budweis, which became Budweiser, and Budweiser, and this so on in all areas, and this was never such a problem, until globalization, because globalization brought competition in export markets. So long as the Americans were using Budweiser in the United States of America, it wasn't necessarily such a problem. But when they start exporting it into other markets, it becomes a question of conflict between systems. And I use one example, but there are many other examples. If Budweiser is not for sale in France, it's because of the Lisbon Agreement. It's registered as an international appellation of origin under the Lisbon Agreement. So what happened then is that the 28 member states of the Lisbon Agreement decided that they wanted to revise it, enhance the level of protection, and expand the register to include geographical indications and not just appellations of origin. Now, a treaty is a contract, and when you revise a contract, only parties to the contract are entitled to participate in the revision. It's a question of privity of contract, of course, and a treaty is just the same. So the Lisbon members said, we are the only ones who will participate with a right to vote in the revision of the agreement. The other countries, if I may so call them, said, no, what you are going to do is such a radical change that it should be open to all states to participate with a vote in the revision. And that has been an ongoing dispute now. The revision took place, but it's an ongoing dispute for 2 years, and it is incredibly bitter. And you find it not just in WIPO, but you find it in the TTIP negotiations. You find it in every bilateral free trade agreement that is being negotiated, either by the United States of America or by the European Union. And it's an example of the way in which competition is being played out on the basis of intellectual property. So look, I have probably spoken for too long. I'm going to keep quiet now and we can have perhaps some interaction. But my last thought that I just leave with you is that in that environment of complexity, I think for a multilateral institution, one of the major questions that we confront now is, what's the role of the multilateral in that complex architecture? Not everything has to be done multilaterally, first. So what things need to be done multilaterally, as opposed to nationally or bilaterally, as the case may be. And secondly, not everything has to be done, not all forms of international cooperation take place through a treaty. You can have international cooperation through a platform rather than a treaty. So it's a very different environment. We need to pay more attention, I think, in the multilateral to the design question of what should be done multilaterally. I mean, if you think historically, you couldn't survive with the use of intellectual property without the priority principle and national treatment. So they have been the typical things that should be done multilaterally. But what now is the case? So I leave you with that thought just at the end, and I'll stop talking there.
Well, thank you very much, Francis. This was really, really inspiring. I'm sure we'll have a lot of questions and remarks. Let me just kick off with one of them just to start the discussion. So all these changes that are occurring in the landscape internationally and nationally leaves one open question on who regulates it. So you mentioned the markets, the technology, the market reacts to technology, but we still have a lot of society issues within intellectual property, and who should actually define the rules of the game. So if it's not the legislator, I understand the legislator is very much under pressure, the multilateral legislator in particular in these times of nationalism and populism or whatever. You mentioned the courts, and the courts are faced with very, very difficult questions to deal with. So we organized a big event at the Council of Europe 2 weeks ago on copyright enforcement on the internet. And on the digital market, the copyright reform, and we put together a lot of different players, including judges, the Commission, the Vice President of the Commission, and the European Parliament. And basically, what came out of this is basically that courts are the ones who have to decide on very complex issues such as website blocking, injunctions, copyright enforcement, intermediary liability. We mentioned all these new businesses. But are these judges well equipped? I remember one judge telling us basically in his talk, most of our judges are over 60. They're not really familiar with all the technology changes that are occurring, but they have to define the rules of the game using tools that are not necessarily also very modern because legislation does not follow. They do not have chief economists like WIPO. So when I see all the, basically all the energy, all the resources that are devoted to make multilateral instruments, basically should not at least one part of the resources basically be devoted to help judges actually to make these decisions and to focus more on judiciary, be it by training or developing tools for them to make these decisions. Because if they have to define the rule of the games, we need to help them.
Yeah. Well, look, I think this is one of the central questions. And by the way, I don't think that it is confined to intellectual property. So if you look at what's happening in the space of big data and privacy, you know, basically business models are being developed and deployed, and we don't have the rules for protection of personal data because that is all going too quickly, and we are not able to have the policy-making processes that can give an adequate response. And I think it'll be exactly the same for ethical questions in the field of the life sciences. So there is a technology called CRISPR that you may be aware of, which allows an intervention on the genome of a person, which intervention will be reproduced in subsequent generations. So you're not actually intervening just on one individual, but you're changing that genome in its reproduction in the future. There's a lot of tension around this, including a court case in the United States of America between, if I'm not mistaken, the Broad Institute in Cambridge, Massachusetts, and one of the universities in California, an intellectual property case. But there is also recently announced that China has started human trials with this technology, which has not started in the United States of America. Well, the reality is we don't have a policy instance that can decide, well, ethically this is okay or ethically this is not okay. So we happen to be at the forefront of that in the field of intellectual property because, and you often ask why, you know, in the case of going back now 30 years actually to the Harvard mouse, which was a patent sought and obtained in certain jurisdictions on a genetically modified higher organism, and whether this was acceptable and ethical. In that instance, you know, intellectual property became the battleground. Everyone said, oh, patenting an animal, this is a terrible thing. The reality is most people eat an animal every day, you know, which is a lot more radical treatment to give it than to patent it. You know, why does it become the battleground? Because the patent application, when published, is probably the first social expression of the new technology. It's being used. It's being developed in laboratories, in secret. The first time it hits the public light is the patent application, and so that becomes the focus. So I'm raving on a bit here, but to get back to the question, we're not alone. I think it's a major crisis in our society, or a question in our society. I had that conversation with the Chief Justice in Australia about 3 weeks ago, who said, you know, we will perhaps have to use experts in a way that we've never used them before. Experts to assist the court. So that's one measure that can be taken. I think another question that comes out of this is the question of coherence. So if you look at the whole, you know, developments and this complexity, multi-layered, multi-tiered, multi-speed, who is the keeper of coherence in this? So who says that the TPP is coherent with the multilateral system, it's coherent with national laws, and so on? I'm not saying it's not coherent. So that is a very important question with the multiplicity of actions everywhere. How do you maintain the coherence of the system? Here, and this is one of the consequences also of globalization. I think we have, you know, made complexity a real problem for ourselves, because basically anyone who at the national level introduces a law, it's going to affect everyone else. If you introduce a law in the European Union, it's going to affect everyone else because people are trading into that market. Complexity, I think we need to look, excuse me, very carefully at our institutions and their capacity to deal with this changed context of science and technology.
Thank you very much. So now I'm happy to open the floor for question and remarks. Just briefly introduce yourself and ask your question.
Hello. Thank you very much for your conference. It has been very, very interesting. My name is Juan Luis Astray. I'm a student here at CEPI for patents diploma. And I have 3 questions. Well, the first is a comment, and I think it's very interesting, because you have talked about law frame that is not changing enough with the same speed as technology does. And I'm thinking that all of patents have started with law and with studies. Diderot created an encyclopedia, and this opened the culture to everyone in the world. Then American-French Revolution established patents law and national education frames. This accumulation of education through 19th century and 20th century have given open societies. The Second World War was the end of a process in creation of free societies with national education frames. This accumulation with the advances of World War II, that is the base of all the technology we have today. Transistor was created because of radar, to open the range of radar. Informatics and computer were created because of ENIAC, to break enigma and television or radio or typewriting things were the basis of much part of technology, and turbine jet reactors for fighters, for plane fighters, are the base of today main technologies we have today. Then that has came to technology revolution we have today, and the issue is this is changing at a speed that law cannot follow. But I think there is a main important thing for our society today and for the economical crisis we have, because I think I was studying in Berkeley in 2007, and we were talking about World Trade Organization and Chinese entrance. We were discussing about dumping, social dumping, and the teacher told us that when it was negotiated, the economical masters in political powers in Occidental world were thinking that all the job posts that were taken in China because of price without technology were going to be created with more value added, with more technology, more intelligence in Europe. But the issue is that this needs more education for students today. 2 years ago, here in SAPI, yeah, the issue is, this is only a point. The issue is, this is creating a brick in today European societies. The crisis that Trump choice in the US is because of education frontier in our Western societies, because the change, all those jobs have created a pressure on education level. 2 years ago, a student here in SAPI asked the OMPI director how many years students here in Europe were going to study in order to arrive to those posts and to those technology speeds. And this implies in our crisis today that education has not been free or less expensive. The students today in Europe and US are paying more. It is a point
we
for
want to have a discussion broadly,
okay.
All right?
The question is when the European countries are going to react. I think it's important because you have the main technology point of view in Europe and the world are going to react to increase the education level of students in Europe and make less expensive the studies in universities in order that the technology speed that are creating a frontier in Europe can be reached by young generations. And I have only to this is not so long.
No,
as
because
this.
there are many other questions, please.
Okay, sorry.
So, right?
I will go.
I think it's more a comment than a question. But look, I don't know that, but I would simply say that, yeah, education, like every other element of the regulatory system, is a base of competition also. Now, so there is competition as part of the competition for human resources. And why is that going on? It's going on to have the right skill profiles in order to be able to compete in this world in which innovation is the central economic strategy.
Okay, so the next question would be brief, please, because we have a lot of, I see a lot of people wanted to ask questions, so please be brief and to the point.
Okay, hello. Regarding the new services like streaming, that you say that it's very interesting that it was something that technology came before law. You think that it is necessary that multilateral treaties came about the subject? Because right now these services are worldwide, but there is not a legal worldwide instrument for them.
Yes, I think that's, if I understand the question correctly, I think you're absolutely right that what we're facing in the world of creative works is that the technology has created a global space, and the business models are global, but the legal systems are territorial, and that's a drama. It always seemed to me, and perhaps I shouldn't say this, but it always seemed to me that if you work on a single digital market, well, it's not like the physical market. There actually are no borders, you know. The single digital market is global. It's not, you can't make it, you can confine the institutions to one space, but the activity is naturally, you know, global. So I think this is a drama. It's very difficult to see the movement away from that because nobody is prepared, I think, at this stage in the world to contemplate an international code of copyright that covers everything and to renounce their national positions. Just look at the difficulty in Europe of achieving that, moving from national to regional, and then you put it in this multi speed and diverse world, and it's even more difficult. So I think what we see is simply gradual movement to the adaptation of the architecture of the analog world to the digital world. And that's a process that will continue to evolve, I think.
Hello, thank you very much for indeed very inspiring speech. I would like to be brief. There is no doubt that intellectual property plays a crucial role in this complex architecture of globalized economy. Yet, with the development of the information technologies, notably blockchains and smart contracts, the IP field tends to change itself. Therefore, my question is, what's in your opinion and how the IP landscape going to be looking like, taking into account the increasing importance of these named technologies? Thank you.
Well, yes, well, it's a great question, and I don't know. I think the jury's still out on blockchain, but there are many possible applications, particularly in the copyright area, where we have this problem of huge numbers of contracts having to be concluded, and blockchain without a central register. And blockchain may be one of the answers to that. I think it's too early to say. Everyone's looking at the technology. But what I would say is, well, it's another example that the solution, if it does happen, it's another example that the solution has come from the market and not from policymakers, which is increasingly the case. Whether we like it or not, I mean, I'm just making an observation here. I'm not saying it's a good thing or a bad thing, but that is what is happening. It's causing us all, you know, to, I think, we should be thinking, what is the appropriate regulatory system in a globalized, fast-moving, technology-based world? And what we have institutions that belong to a completely different world and were developed in a completely different world. So how do we address that? And it's a long, long process, I think.
Xavier, please.
Thank you very much. This is Xavier Saua from SAIPI. Thank you very much for your lecture. It was very inspiring as well. I think I have a short question, but probably is a long issue. No? What do you think that can be done to improve the social perception of IP? Because I think that we are dealing with very complex issues, very complex debates, but at the same time there is a risk that society does not understand the complexities of the debate. So probably WIPO and yourself have a view on this. So thanks.
Yeah, look, it's a great question too. And it's a very difficult thing. I think, you know, our problem in the field of intellectual property is that we're selling a long-term advantage for a short-term, in return for a short-term disadvantage. So the short-term disadvantage is people have to pay. The long-term advantage is you have mechanisms that create the appropriate incentives for the development of new knowledge, which is going to address some of our social challenges. And you have mechanisms for the development of, enabling a sustainable economic existence for creators and the creative industries. But that's a long-term thing. And the short-term situation confronted by anyone is, oh, well, I have to pay for this. But it might be possible not to pay for it. So we have a big sales job to do. I agree with you entirely. It's a terribly difficult question to how are we going to sell the advantages of this system. We need a lot of, I think, help on that, because now everyone's involved. You know, we may have had to convince a few policymakers 50 years ago about tweaking the patent law, but you try to do it now and you have the whole of society watching exactly what is happening. And it's a much more difficult environment in which to move. And we have to, I think, just emphasize the reasons why we have intellectual property protection, which are music, films, you know, the creative works that enrich our lives. You have to find a sustainable economic basis for that. And saying innovation, new knowledge, new ways of addressing the social challenges that we face.
Hello, my name is Alexander Bulayenko. I'm also from SAPI. I have a question related to the importance of language for the acceptance of intellectual property. I very well remember your comment during your last conference at SAPI, where you mentioned, you expressed an idea, a thought that it might be interesting to consider speaking about confidentiality protection instead of, for example, trade secrets, because confidentiality is more positively perceived than, let's say, secrecy. And very often when we speak about intellectual property, we speak about innovation. It might be, well, the two things, intellectual property and innovation, might not necessarily be synonyms in all given situations, but sometimes this simplification can be quite useful. It can be easier to convey the message when giving examples about innovation, speaking about importance of innovation, because it's easier for everybody to agree. It's like World Health Organization, it's easier to agree on health. And I just wonder about what your thoughts are about cases where actually these simplifications might not be going in the right direction, where it might be advisable to speak about intellectual property rather than about innovation.
Look, I agree with you entirely. I think we do have to pay attention to the terminology. And if you, as you know, some of the people who are opposed to intellectual property are very, very good at developing terminology which is immediately eye-catching, immediately, you know, digital locks, biopiracy, there are many words that they have developed in terms that are very attractive, frankly. And we in the intellectual property world are a bit slower. But I agree with you. I mean, we should persist and be emphasizing, pay attention to terminology and be emphasizing things like innovation, where you have a chance. Because you mentioned the World Health Organization, which I did also, but calling us the World Intellectual Property Organization is like calling the World Health Organization the World Vaccines Organization. You know? So vaccines are necessary, they're not very pleasant, but they're necessary for health. Intellectual property is, I would argue, a necessary but not sufficient condition of innovation. But what it's for is innovation.
Hi, I'm Florence Tepo. I'm a lecturer in competition law at the University of Glasgow and also a member of Create Research Centre. I have a question about the role of platforms. So you explained that now large companies are being key actors of the drastic changes. And of course, there are typically large platforms which have significant degree of market power. So in other words, would we like to have more competition in these fields? And how does market power affect the innovation rate? And also, is there an inherent tension of interest between consumers who seem to benefit quite a lot, at least in the short run, from having this access to a wide range of music or culture at cheap or very...
Well, yeah, also a great question, and I go back to what was said by the gentleman earlier about the copyright scene. In fact, I think there's a lot of anxiety, particularly you can see it expressed a bit in Europe, about the gigantic corporations that exist. Now, one of the, how is that dealt with? especially in the IT creative content area. How is that expressed? In Europe, it's excuse me, it's expressed through competition law, as you suggest. But the reality is that, of course, competition law is bound by the territorial restriction of the laws. So what you're dealing with is the European market. But the real question may be the global market. The real question in relation to creative content may be, you know, what is the position of Netflix in the global market? And is it a dominant position or not? Or Google, as the case may be, or you know, YouTube, or whatever it happens to be. We don't have the tools again. You know, the behavior is global, the technology enables that global behavior, but our institutions are all rooted in the national, including the market. We're considering, is there a market abuse in a particular territorial market? But the real thing is, you know, look at the power of this corporation worldwide. We have no way of dealing with that, actually. So, yes, I sympathise with the thrust of what you're saying, and it's a very fertile area. But then again, you have only a limited number of countries in the world that actually have competition laws. So, you know, it's a very uneven playing field.
Okay. We still have 10 minutes to go, so feel free to ask a question. Come on. You got your turn. You got your chance. Okay. Well, then I'll use my my power as chair to ask one more, because, and this might be a little bit more of I don't know, a question to the global citizen that you are, of course, directing such a big institution such as WIPO. So when you see, of course, as a global citizen, you watch news, you see, you know, that there is a rhetoric against multilateralism. There is a temptation that we see at many national states. We see it in Europe. We see it globally. On instead of looking at global opportunities, starting to concentrate on national markets, national systems, build walls, barriers, again, and my question would be, do you see that affecting your work as a multilateral organization? Because one of your aim is, of course, to develop global standards, or are there some concrete effects on that, or is it still virtual at the moment, and there might be some potential implication in the future, or are you immune to this kind of political policy trends, actually?
I think that it's this is something we need to think about a lot. What does protectionism mean, and what does anti-globalization mean in intellectual property? And I'm not sure we understand that yet. So let me give you one example. I mean, it would be a terrible thing if patent granting authorities, intellectual property officers, start to take decisions on the basis of extraneous considerations. You know, not whether this is a patentable invention, but whether actually it would be inconvenient to have a property right on this piece of technology in this jurisdiction. And there, I think, there is activity going on. You know, there is. And the only solution to that, I think, is transparency. So sometimes I've thought, well, it would be a good thing to have a website in which people could spontaneously come and say, here, I can show you that I got patent protection in all these countries, but not in 1, 2, and 3. And it's not saying that those 1, 2, and 3 are wrong, but it's shedding light on the problem. So that's one form of protectionism, I think, that is going on, and it would be a disastrous thing if that continues. I think there are other forms of protectionism or anti-globalization which I think can be extremely inconvenient in the sense that they can lead to a very incoherent system. I mean, we have no choice basically but to be coherent, because that's, unless we completely go back on globalization, completely, which I doubt is actually possible. But if we are stuck with globalization in a certain sense, and we're stuck certainly with the technologies that have generated a lot of globalization, for example, the internet. That being the case, if people start making protectionist measures all around the world, we can end up with a completely incoherent system. And I think that's another danger. But we have to think more about, you know, what does protectionism mean in our field of intellectual property?
Excellent. Okay, so if there is no further question and remark, what is left for me is to warmly thank you for taking the time and to share your thoughts with us. And of course, you have an open invitation whenever you feel like to do that again. Thank you very much.